Worship, today is 7 August 2025 in the Magistrate's Court, sitting at JP Karoehe Street, in the matter between the state and Immanuel Mulunga and 14 others, case number 854 of 2025. Presiding officer, Mr. Samunzala, for the state, Mildi Lungwe, for accused 1 and 3, Mr. Bangamavo, accused 2 and 14, Mr. Isaacs, and I see Mr. Cupida is here, standing in for Mr. Isaacs. Accused 5, 6, 7, and 10, Mr. Namanje. Accused 4, Mr. Kasper. And accused 9 and 15, Ms. Gebhardt. And we are ready to proceed.
Morning, Your Worship. Please, the court, Your Worship. I still appear on behalf of accused number 1, fourth and fifth applicant. Please, the court, Your Worship.
May it please the court, Your Worship, I continue appearing on behalf of accused number 4.
Your Worship, may it please the court, I appear for accused 9, applicant number 7 in the bail proceedings, as it pleases the court.
Your Worship, I still appear for accused 2 in this matter.
As the court pleases, Your Worship, may I continue with cross-examination?
You can proceed.
Now, if the witness could be given exhibit D1. D1, I'm not too sure whether it's part of those other bundle. D1, in particular at page 271. Check if there is D1. Yes. Thanks.
What page?
271, Your Worship. D1, insert 1. It's on the continuation, Your Worship. I think it's a continuation. So,
are you there? 271.
I'm there, Your Worship.
Now, yesterday, you remember that is the internal memo by Olivia Dunaiski to Immanuel Mulunga. You spoke about it in your evidence in chief.
That's correct.
And in one of your statements that you made when you were being led in evidence in chief, you said this initiated the, if I understood you, the criminal activities. Or did I get you wrong?
Definitely you got me wrong.
Or what did you say? What did it initiate? You did use the word initiate.
Initiated, or rather subsequent to this document,
subsequent to that document,
the commercial offer was given to NAMCOR, to Enercon by NAMCOR.
Okay, that is even better. So it did not initiate criminal activities, as you confirmed now.
Not entirely correct. In fact, totally incorrect. We are having charges of conspiracy. And we know that in my examination in chief, I indicated that as far as the evidence we are having is concerned, the acquisition of the assets started already by May. In fact, in my examination in chief, I indicated the 10th of May. That is the earliest records that we have.
There you start with answering something I didn't ask. I started off saying, did I understand you correctly that you suggested criminal activity started with this document? You corrected me and said, no, it is what happened subsequently. Now, when I said, okay, it's even better if it did not start criminal activity, you start changing your version. What is what?
Criminal activities, especially of conspiracy, can well
could have well started even before the 10th of May 2022, because the records that we have in terms of evidence just cemented the discussions that could have taken place. So your question was specifically if the criminal activities were initiated after this.
Yeah, but you no, I never said after that. Today, don't misquote me. Today I never said, I said, did you not say this document initiated criminal activities? I did not use the word after. You must listen to the questions, please. Okay, so what was initiated by this document, just for clarity? You used the word initiate yesterday.
I've answered it already. I said the commercial offer.
Okay, good. Now, this document, Mr. Peter Elindi and Malakia Elindi both stated that, first of all, they were not aware of its preparation because it's in an internal document, and they have nothing to do with its preparation. What is your comment, if any, in that aspect? That is evidence they gave. Do you have any comment, or you do not have?
I was waiting for you to be done with your phone so that you pay attention to my response. Although they may not have been aware of the production of this document, they were aware of the undertakings, because the planning of the activity started even before 10 May 2022.
Sir, I'm not asking that. My client stated they did not have knowledge of preparation of this document. Do you have evidence that they have had knowledge of the preparation of this document? Do you have such evidence?
When the evaluation was conducted already before this document was produced, Enercon's representative accompanied NAMCOR's engineering team. So even if they were not instrumental in the creating of this document, they were well aware of it.
Listen to the questions. I'm not asking, you said the team, engineering team, was accompanied by a certain Thomas, what is the name of the person you said?
Matthew Iambo.
Yeah, Matthew Iambo. I'm speaking about Peter Elindi and Malakia Elindi. Do you have evidence that they knew that this document is being prepared? I'm asking for evidence. Do you have?
It's common cause if an entity sends its employees out, that employee need to be authorized to go and do that.
I'm not asking about that. Do you have evidence about this document?
I've answered your question, Mr. Namanje.
No. You are not answering the question, please. You are not answering the question. If you do not want to answer, then you must say, listen, wait until I speak. The question is very specific. This document was prepared on the 8th of July, 2022. You see that?
That's correct.
Let's start with Mr. Malakia Elindi. You are the investigating officer. Did you collect any evidence showing that he has personal knowledge that there is an internal memo dated on the 8th of July addressed to the managing director by Ms. Olivia Dunaiski? Do you have such evidence in your docket?
I've answered your question, and I will repeat again. I said, although they were not involved in the production of these documentations, they were well aware of the engagements, because by May, we have already demonstrated evidence that by May already, the undertakings for the acquisition had already commenced. No. So this was an internal process. Of course, they were not involved in the document, but they were aware.
Aware of what? Of the document?
Not of the document.
Okay, that's what I wanted. So they were why did you take long to answer? So your answer is that they were not aware of the document. Let's move to the one paragraph in the document. Now, go to the next page. Read the first paragraph.
Additionally, NAMCOR would like to become the preferred supplier to the Ministry of Defense in the long run, and through acquiring these assets, it will put NAMCOR in a favorable position for future business relationship with the Ministry of Defense.
Mr. Mulunga confirmed there's nothing wrong with that. That yes, this was a strategic policy decision, a commercial decision. Do you have any comment?
Yes, Your Worship. I have a comment.
Yes.
When I read this paragraph,
Yes.
we can divide it in two folds. The first part of the paragraph says, additionally, NAMCOR would like to become the preferred supplier to the Ministry of Defense in a long run. That is number one. Meaning the intention of NAMCOR was in a long run to become a preferred supplier of petroleum products to the Ministry of Defense.
Yes.
Now the second part, through acquiring these assets, it will put NAMCOR in a favorable position for future business. So meaning, through acquiring meaning buying and purchasing the assets
Yes.
that they wanted to buy.
Yes. Yeah,
Answered.
that is what he said.
Yes.
Yes, so you agree with him. Then go to the next paragraph and read it out.
The feasibility study results were favorable in acquiring the assets of Enercon Namibia worth 53,212,000 Namibian dollars.
Okay, just end there. Do you know what feasibility study is being spoken about?
The discounted cash flow.
Okay. Do you know what is a discounted cash flow?
I've seen the document during the investigations. I have sought explanation as to what was the intention of the report.
No, but I'm asking generally.
Yes,
By training, do you know what is it?
of course.
Okay. Go to page 243. Or same document, 243, Your Worship. Now, in your docket, are you in possession of the document from page 243, Your Worship, to page 263? In your in your ACC docket for this case, do you have this document?
Yes, I do.
Okay. Who prepared it?
The document was prepared by a financial analyst employed by NAMCOR. His name is Sam Hashela.
Sam?
Hashela.
Okay. What did you ask? What qualification he has?
Your Worship, I don't think I've asked what qualification he has, but we have gone as far as asking what experience he had,
Yes.
how long he's been working for NAMCOR, what his responsibilities were, and so forth and so on.
Okay, that is the man that gave a favorable feasibility study on the basis of which it was recorded by Ms. Dunaiski that the feasibility study was favorable. Is that correct?
That's correct.
Now, just comment, my clients were not involved. Peter Elindi and Malakia Elindi were not involved in this feasibility study.
Definitely they were not.
Okay. So it is an internal process to determine whether it is worth buying and acquiring the assets of Enercon. Do you agree with me?
I agree with you that it was a feasibility study with determining the viability of the buying of the assets.
Yes.
Thank you very
And
much.
it was favorable.
Yes.
In other words, the person the professional who prepared it, gave it a go-ahead, so to say.
Definitely.
Okay? And this was necessary so that the department concerned could then make a recommendation to the MD. It is very clear from the document.
That's correct.
Okay. Now, you have been talking about planning and arrangement and undertaking and criminal activities. Of course, you have been contradicting yourself. I will come to that. But was this part of the criminal activities you refer to, this document, preparation, or this one is something else? Is a clean, legitimate, no criminal activities involved?
Your Worship, this is an instruction which was given to a staff member. Based on the variables that were provided, the report was generated.
Yes, no, I'm just asking. So I just want to be sure. Is it part of criminal activities, the activities of Mr. Hashera preparing this document? Is it part of criminal activities based on your investigation?
Based on the investigation, this is part of the documentations that was used to create a misrepresentation.
Create a misrepresentation by who?
By who?
Yes.
We have been talking about one misrepresentation that was done all along.
No. Listen to the question. A document prepared so that somebody could make misrepresentation. Who used this document to make misrepresentation?
The requester of the document.
Okay. Making misrepresentation to whom?
Mr. Namanje, the ultimate misrepresentation happened when the contract was signed. Meaning some of the sub-processes that were followed. When a subordinate is requested, for example, when Sam Hashela is requested by Cedric Willemse, not Cedric Willemse, Your Worship, Mr. Willemse and Mr. Dunaiski to prepare the report. This is a staff member that is preparing a report and he's given the information.
Say, are you serious?
You should may I just rise and say, I'm not aware of a Mr. Dunaiski in this court. You heard the witness saying Mr. Dunaiski, Your Worship, so I'm sure he's referring to a Mr.
I'm referring to Ms. Dunaiski.
Yes, can I proceed?
You can proceed.
Let me, I'm saying, are you being serious when you testify now? And you are confusing me as a lawyer. You said this document was prepared so that a misrepresentation is made. This is as far as NAMCOR is concerned, because it's a NAMCOR document. I just want to understand you. Is that what you are saying?
Your Worship, I think I've been serious since I came in this court. I've been serious from the moment I was assigned the investigations for me to investigate
Just
the case.
answer the question, please.
So, but at least we need to remove the statement as to whether I am serious or not.
Answer the question.
The document was prepared to make projections as to whether the undertakings were feasible whether it was feasible for NAMCOR to acquire the assets, and it was done.
Yes, but you are not answering the question. I want to understand it was prepared so that a misrepresentation is made. This is a NAMCOR document. I just want to, who at NAMCOR was going to make a misrepresentation as an individual with this document? Is it Mr. Hashera?
This document was not used alone. It was used together with other documents, which at the end of the day resulted into the agreement to be signed.
Fine.
And when the agreement was signed, that's when the misrepresentation occurred.
Okay, but if it was used, this document was never, do you accept that this document was never ever offered to anybody, given to anybody by my clients, the two Elindi brothers? was never. They never communicated this document ever to anybody. Do you accept that?
I accept that.
Okay. So if they have never offered it, if they have never communicated it or passed it to anybody, they will never have used it to make misrepresentation to anybody, both in terms of a matter of practicality and in law.
Your client has not been charged for fraud in respect of this document.
Okay, good. Let me move. So then, this is maybe some internal fraud we are talking about.
That is why there's fraud in respect of the staff members, is because there was a misrepresentation towards their employers.
Okay, fine. But the document on its own, Mr. Hashera did his work professionally, legitimately. The document in its own, it's legit. It's fine. There's nothing wrong with it.
I believe so.
How can you believe so, Mr. Inambao? Turn to page 17 of the same document. Your Worship, I do not know whether my colleague Advocate Lilungwe gave the witness also the first part of the bundle, D1. Let's just make sure that the witness also have D1. Yeah, D1. From page 1. Yes. Page 17, the second amended particulars of claim. Now, are you aware of a civil case instituted by NAMCOR, the holding company, and NAMCOR Trading against a number of persons, including my clients? Civil case.
I'm aware of it.
Did you ever read those documents as an investigating officer? Particularly the particulars of claim.
Your Worship, I have been busy conducting criminal investigations, and we have been busy gathering investigations so that we wrap up the investigations. So I never had the opportunity of reading this document.
Okay. So then the answer is that you were aware, but because you are still busy, you never got time to read the particulars of claim.
I didn't read the particulars of
Okay.
claim. I believe I answered that question already.
Okay, let me surprise you. If you can go to page 22. 22. Now, can you read paragraph 22 at page 22, Your Worship? Paragraph 22, read it.
The purported recommendations by the 8th defendant
And just for your information, Mr. Inambao, so that I'm fair to you, the 8th defendant being referred to in the particulars of claim, Your Worship, at page 18 is Ms. Dunaiski. Just for your information, so that proceed.
The purported recommendations by the 8th defendant and purportedly supported by the 9th defendant.
Just hang on there, so that, because you said you haven't read it, the 9th defendant, Mr. Inambao, Your Worship, at page 18, is one Davis Mafosa. Yes, go on.
And approved by the 5th defendant.
And the 5th defendant is Mr. Mulunga at page 18, Your Worship. Yes, go on.
Also followed upon a project feasibility study by a certain Mr. Hashela, the financial analyst employed by the second plaintiff, and which was based on the discounted cash flow DCF analysis. The DCF analysis was not appropriate in the circumstances because.
Yes, okay. Now, the particulars you haven't read. Now, this work by Mr. Hashera has been criticized in this particulars of claim as just a sham process, according to NAMCOR. Are you aware of that? In other words, NAMCOR has told a different court in the buildings neighboring this court that this work by Mr. Hashera was not appropriate and it was criticized and so forth as part of a sham process. So is this the first time you are hearing it?
It's not the first time I'm hearing,
Yeah.
but I don't think I should be able to comment on what happened in the civil court. I should be able to comment on the evidence that I've testified on or the evidence that we have gathered during the criminal investigation.
No.
Besides, the burden of proof in the two matters is totally different.
No. Don't go to the burden of proof. It will be dangerous there. All I'm trying to say is that, do you trust NAMCOR? Because NAMCOR appeared to reconstruct its version whenever it suits it. In a different court, it relies on the same agreement and accuse employees of creating sham documents, including the valuation.
Your Worship, as to whether I trust NAMCOR or not, I am looking at the pieces of evidence that we have gathered during the investigations.
Okay.
There was no point that NAMCOR had, didn't say it was sham. Even in the complainant statement, he did say so.
In the complainant statement, what happened?
I'm saying, even when the incident was reported,
Yes.
that was said.
Oh, so who said that?
I testified in the examination in chief as to who reported the case.
No, just state, please, when I
Mr.
ask-
Kongoro.
Yes. So he accused who? Mr. Hashera,
Well, he accused the whole process.
including Mr. Hashera.
Mr. Namanje, don't put words in my mouth.
No, you are saying, please.
No, he said it was a sham report.
Okay, the one prepared by Mr. Hashera.
Yes, we know it was prepared by Mr. Hashera.
Okay, so then he made allegations of being part of the fraud against Mr. Hashera. Remember, we don't have that statement. You have it.
Yes. Mr. Namanje, I don't know why we are going there.
No. Answer the question. Did Mr. Kongoro accuse Mr. Hashera of being part of sham process, fraudulent process?
Yes, he did.
Okay. So there are more people accused of fraud in relation to this matter at NAMCOR.
I suppose you know that, Mr. Namanje, when I testified in the examination in chief, I said part of the outstanding processes is to secure other suspects who are not yet before this court.
Okay. So, but they were accused in the same manner, in the same document. You pick and choose some.
Not necessarily. Mr. Namanje, a person can say you are a suspect. The investigations need to yield evidence indicating and proving that indeed this person has committed an offense.
Okay.
So it's not that we basically just pick up every person because somebody has said this person is a suspect. It needs to be guided by pieces of evidence.
Okay, you doubt the allegations by Mr. Kongoro that Mr. Hashera was involved in fraud.
It's not doubting. Mr. Kongoro is not an investigator. ACC investigate each allegation and based on the evidence that we establish, that we find, then, charges would be instituted based on the amount of evidence that was gathered.
But there is still public interest then, in relation to this matter.
Of course.
Okay.
I mean,
People
that
can
is-
get bail.
That is why we are here. There's still it's because of public interest.
Okay, fine. Let me address another matter. Did Mr. Kongoro also accused Davis Mapotsa, who is sued in the civil case? He's a defendant.
Your Worship, I don't know why I must be answering questions of a matter that was dealt in the High Court in the civil case. Your Worship, I'm supposed to be answering evidence pertaining to Mr. Namanje's client and them being released to bail, or on the pieces of evidence that I've put before this court?
No. I'm asking about this case actually, because remember you have been making loose statement yesterday of my client involved in the planning and conspiracy. No, I'm asking about people that worked on this very matter. So all I want to know is, did Mr. Kongoro also accuse Davis Maphosa, so that I can be specific about Mr. Peter Elindi? Did he do that?
Mr. Namanje, as it's indicated here, you can see there's a lot of plaintiffs. But my response would always be the same. Anybody can come and say this person has committed an offense, but we need to find evidence in order to arrest this person. Besides, we have just indicated before this court that the matter is still under investigations.
Okay, no, but I'm not asking.
So I don't know why, Mr. Namanje, you want me to be able to confirm to you as to who is the person that is listed as a suspect and not. You are actually trying to compromise my investigations here.
Your Worship, I find what is happening here very disconcerting. Your Worship, this witness must be called to order. Yes. You can see the witness demeanor. Look at his face there, Your Worship. Why is he angry? Why is he frowning? He's here as a witness to this court, Your Worship, not because we want him here. He should simply answer questions posted to him. And Your Worship, this is cross-examination. The witness cannot decide which questions he will be asked, which questions are relevant. It is for this court, Your Worship, to order where there is an issue of irrelevancy. This court will step up and order that, well, this is irrelevant, you cannot answer. But Your Worship, this has gone on for far too long. This witness must be called to order.
Just to add, Your Worship, you remember, Your Worship, when my clients were testifying, applicants, a number of times the court did caution them that when my colleague was, that they must answer questions. I think the same must happen with this witness. Yes. I'm doing what I have taken an oath to do, and I need to do my work.
Your Worship, it is very clear. I think even the tone of Mr. Namanje, sometimes he screams at the witness, but there is no issue with regard to that. I think that's how the witness is answering. So he cannot be said that he is frowning. If that was the issue, I think the court would have raised it. I think going forward, if there is an issue, it must be addressed right there and then. So I do not think the witness is angry. Perhaps it's just the manner in which he's answering, and he's answering questions that have been put to him. And I think in all fairness, the witness is here in a bail hearing, not to comment on cases that relate to a case in the civil court. We are not in the civil court. I think everyone else is well aware of that.
Your Worship, with greatest respect, this is one and the same thing. I'm entitled to take the witness to any document that is part of the civil case is part of the exhibit handed up here. My colleague did not object. How can I not ask the witness about document handed up as exhibit? Why were they handed up? Your Worship, just like our clients, the witness must answer questions.
Yes, it's the court have not seen the witness frowning. Yes, for the record, I have not seen him frowning. He does not appear to be angry to court. He's simply responding to the questions. Now the witness is on record. Mr. Namanje, you are putting questions. If, for example, he is not answering your question the way you want it, we have already indicated that is his answer, and we are on record. You direct him, my question has not been answered, I move on. But that is his answer. The court cannot tell him, or we cannot tell him to answer what you want. He is responding as he deems fit, and we are on record.
No, I think, Your Worship, you, with respect to you, misunderstood the complaint. The complaint is not that he must give the answers counsel is seeking. What he cannot do, he cannot avoid answering a question asked. If he cannot answer, then he can say he cannot answer. Your Worship, it is different. A witness must answer the question asked. But he cannot try and answer something else and say, I have answered. There's a difference, Your Worship. Our complaint relates to the fact that he must address the question asked. Those are two different things. So if I ask a question and he starts answering something else, it's your duty, your worship, with greatest respect, to direct the witness to attend to the question being asked by counsel. Otherwise, there will not be justice. So it's two different things. A witness has no freedom, has no liberty to answer everything he thinks is nice to say. He got to answer. I don't care whether the question is bad or good, but he must answer the question unless it is my question is objectionable. But if it,
But I hear the witness is responding to your answer. So if he is not responding to the answer you posed to him, put it to him, that is not the answer, that is not my question.
Exactly.
My question is like this. Yes.
Okay, let's go on. Let's monitor that. Let's monitor that. I'll continue. I'll continue
Yes, so
monitoring.
if he has not responded, say, please, that was not my question.
Okay.
My question is this one. Do you have an answer to that question or not? So that we can.
That's
then
a good
and
ruling.
then
A good. Listen, sir. Please listen carefully to my questions, and only answer my questions. I start again on this question.
Sir, you are informed. Answer the question. If you have no answer, simply indicate I have no answer or comment, so that we can move on.
Go to this question again. You talked about the complaint, Mr. Kongoro. All I want to know, did he accuse this 9th defendant in the civil case, Davis Mafosa? Did he accuse him of being part of the fraudulent activities?
No comment.
Okay? I want to just give you a benefit, but you can, it's up to you. I'm not forcing you. Is there a reason why you are not commenting on? Do you have any fear? Why?
Mr. Namanje, whether you like the answer which I have given you or not, I've just answered you. You wanted an answer?
Move on. Yes, Mr. Namanja, we move
Okay.
on. Your answer is answered. Your question.
Now let's go back to the to another document. We move to, Your Worship, back to page that deals with the Mr. Hashera's document. Now, do you know that Mr. Hashera determined that within 4 years of the asset purchase agreement, NAMCOR, according to his projections, would have recovered the purchase price by exclusively supplying petroleum products to Enercon, so that Enercon then supplied Ministry of Defense through those assets. Are you aware that the feasibility study, according to the document and Mr. Mulunga's evidence, within 4 years, the projections are that the 53 million would have been recouped, recovered. Any comment on that?
Your Worship, and I want to make sure that I answer you correctly, because your question, the first question, was in two folds.
Okay.
You said in the supply of fuel at the end. The feasibility study was aimed at, you are correct that it was aimed at establishing as to whether the project is feasible or not.
Yes.
And in terms of the study, NAMCOR Trading could recoup its investment in 4 years.
Yes.
But it was not aimed at the supply of fuel. It was aimed at purchasing the assets.
What are you trying to, you are contradicting yourself.
And hence I said, because you mentioned the supply of fuel, and I want to make sure that I'm also clear that when I'm giving you the response, it's not that I'm agreeing that it was to the supply of fuel.
No. Let me go. The feasibility study found that NAMCOR will be able to recoup and recover 53 million it paid to Enercon within 4 years. Yes or no?
Yes.
Okay. The feasibility also found that the remaining period would for it then to make profit.
Correct.
In addition to recovering the purchase price.
Yes, correct. On the assets that they were buying, not on the supply of fuel.
Oh, no. Look, what do you mean on how do you make profit on the asset you buy? What do you mean?
Your Worship, we have just read the internal memo of, you made me to read the internal memo of Ms. Dunaiski. It was talking about the purchase of the assets. The feasibility study was in regards to the purchase of the assets.
Yes, we are on the same page.
Thank you.
But I'm saying, when you how was NAMCOR going to recoup 53 million? Is it not to supply Enercon exclusively, that no other supplier will supply Enercon? It will then recover 53 million. That is what the report is saying. That is what Mr. Mulunga stated.
Your
And
Worship,
that is what the asset purchase agreement is saying. I will take you to the agreement.
Your Worship, the transaction happened on the 18th of July.
I'm not asking about it.
And just allow me to just give you an answer. It happened on the 18th of July.
Yes?
This, Mr. Mulunga left the office by April when he was suspended.
Yes.
Until then, NAMCOR never got anything. So how were they going to get anything in the end?
What do you mean NAMCOR never got anything? What do you mean? What are you trying to suggest? When you say NAMCOR never got anything, it got anything. It sold products to Enercon according to the asset purchase agreement, and I will show you.
That's what you are saying.
Okay, I will go to the agreement later. Let's go on. Let's go to the valuation of assets. In your docket, you have the valuation of assets.
That's right.
Who did the valuation of assets?
Nesta Shefeni and Michael Ipanda.
Okay. According to your investigation, did they carry out their professional duties legitimately, ethically, without involving themselves in the...
Object to that question. It goes down to the issue of relevance. How relevant is that question with regard to the issue here? I do not think we are busy with the issue of valuation of assets here.
Oh.
It's not relevant.
Oh, Your Worship, with greatest, do I even need to respond to that? The valuation of asset is at the center of this matter. Even my colleague led cross-examine to my client on the same issue. How stingy is he? He could ask my witness on the valuation, but he does not want me to ask questions on the valuation. Can I proceed, Your Worship?
This aspect has been dealt with. The court will overrule the objection. You can proceed.
Let me just say why I'm asking those questions. Remember, in the charge sheet, my clients are not alleged to have conspired with Mr. Mulunga. I showed you yesterday.
You were asking the question. I thought you were repeating the question so I can answer it for you.
No, I'm trying to make it clear to you. Please just listen to the question.
Sure.
You remember yesterday I took you to the charge sheets against my client, and I showed you that as far as these charges are concerned, my clients are not charged with conspiring with Mr. Mulunga. You remember yesterday?
I hear you. Yeah, I remember.
Okay. But at some point you made general statement that my clients must have been involved with employees of NAMCOR. You made such a statement yesterday. Or I misunderstood you.
Well, we are on record right now. I'm not.
You are not
I
sure?
can hear what you are saying, but just proceed.
Okay, fine. I just want to check something with you. The valuation by Shefeni and is it Mr. Haipanda?
That's right.
As far as you are concerned, is it a fraudulent document or it's not a fraudulent document? As far you said,
As far as I'm concerned,
yeah.
the individuals had visited the sites in question. They did what they went to do there and provided a report.
Yes.
So for me to say whether it's fraudulent or not, it's not something that I can say because the people went to the sites. Okay. They saw the sites, they took measurements, and after that they produced a report which was brought to management.
No, I think you misunderstood me, Mr. Mulunga. I'm not saying say that it is fraudulent. I'm asking whether, from your perspective as an investigating officer, it is a fraudulent valuation. I'm not saying say it is.
No, I think he has answered. He said he cannot say it was
Okay,
fraudulent.
yeah, exactly.
Yes, we can move on.
And now, if you cannot say that, am I correct to say the amount that was offered by NAMCOR to my clients for the asset was determined exclusively, internally, properly, and legitimately by NAMCOR?
That's correct.
Okay, good. Now, let's then go to the agreement and show you that NAMCOR did get something, and Mr. Mulunga's evidence as to what was contemplated in the agreement is very correct. Let's go to the asset purchase agreement, Your Worship, at page 50. Page 50. '51. Are you there, Mr. Inambao?
I'm there.
Now, just listen to it so that you understand where I'm coming. Are you aware that the two public prosecutors in this court have suggested that NAMCOR did not get ownership of the assets? Are you aware of that?
I'm aware.
Okay. They have also suggested that Enercon ought to have stopped using the assets, the pumps, the tanks, so that NAMCOR take over. Their cross-examination of my client suggested that they misunderstood that Enercon ought to have walked away with the 53 million and NAMCOR would have started directly supplying the ministry. Are you aware of that?
I'm aware.
Are you the one responsible of that understanding by the prosecutors? Are you the one that suggested that to the prosecutors?
Investigations was conducted.
Yes.
Evidence was presented to the prosecutors.
Yes.
So that understanding comes from the evidence that was gathered.
Is that the evidence you gathered that Enercon, once the agreement is signed, Enercon would have walked away, NAMCOR would have taken over the pumps and directly supplied the ministry? Is that what you have gathered with your investigation?
The evidence gathered shows that Enercon was buying the physical assets. The physical assets that were evaluated by the engineering team.
Yes.
So that is the understanding.
NAMCOR was going to buy right, interest, and title in the asset as appear in the asset register and in the valuation.
No, that is misleading. And I'm saying it's misleading because NAMCOR was buying the assets. They were not buying the rights. And that is what that's what stands on the commercial offer, and that's what stands in the contract.
I pity you. Can you buy asset without buying the related rights?
Well, the rights, of course, if you buy the assets, they become yours.
Yes, that's what I'm saying. So they bought the title, right, and interest in the assets.
No. When you are saying in the assets, you are excluding the physical assets.
Who said that? I never said that.
You just said in the assets.
Yes, that's what the agreement is saying.
Okay, I hear you. It appears that you are in agreement. Yes.
Yes,
we can move on.
let's start at to show now, and this is with greatest respect, very, very concerning, that a distortion was put to my client by the public prosecutor using something apparently you gathered. Let's start. let's start at the top.
Object to that line of question. I think you can just put questions without actually putting blame on me or disrespecting me in a polite but rude manner, because I can also do that. I can reciprocate.
No. But, Your Worship, I never suggested any dishonest on the part of my colleague. I said prosecutors asked questions that are a distortion because of what he gathered. And I will demonstrate that that was a distortion. I'm entitled to say that.
Can you put the question?
Yes. Let's start on the at page 51. At page 51, first of all, do you know a principle called parole evidence rule?
Your Worship, I'm not a lawyer. I am an investigating officer, and I think I've indicated that yesterday.
No, I just asked if you
No.
know. Okay. Now, do you see that the agreement on the face of it, it says that the managing director was jury authorized?
That's correct.
Okay, that's what the agreement is saying. Then over the page, let's go to page 52. If you can read the second paragraph, which starts with whereas Enercon.
Okay. Whereas Enercon is the owner of certain bulk storage facilities comprising those assets and any and all equipment used by Enercon in conjunction with the operations of the said asset set forth in Exhibit B attached hereto,
Yes.
herein after referred to as the assets.
Okay, now, first of all, it's common cause that this positive assertion that Enercon is the owner, this is drafting work, authoring work by NAMCOR legal department, is that correct?
That's correct.
And the legal department must have worked with the team of NAMCOR that visited the sites where the assets are.
That's correct.
Okay? So in other words, it must be taken that NAMCOR, through its investigation team, the team that evaluated the asset and the legal department, to draft and author this part, they must have familiarized themselves with the ownership state of the assets.
Your Worship, I believe that was the purpose of the feasibility study that we, feasibility report that was presented, and as well as the evaluation report.
Okay.
So the legal team would have had access to this documentation.
Yeah, hence they said Enercon is the owner of the assets. Then let's move on to the next paragraph, the third one.
Whereas Enercon desires to sell, transfer, and assign to NAMCOR Trading all of its rights, titles, and interests, and to those assets as set out in Exhibit B, and any and all equipment used by Enercon in conjunction with the operation of the said assets and located on the premises set out in Exhibit B.
Okay, now, remember now, we were talking about right in the assets and so forth. Now, if you can just read out paragraph 1.1.
1.1.
Yes, that is the very important paragraph, what is being sold. If you can just read out for the record.
1.1, purchase and sell. On and subject to the terms and conditions of the agreement, NAMCOR Trading agrees to purchase from Enercon, and Enercon agrees to sell and transfer to NAMCOR Trading all of Enercon's rights.
Yeah, okay, just park here. Enercon's, the first one, right? Do you agree with me?
Yes.
And what is the second?
Title.
That is number 2.
And interest.
Yes. What is the word that is next?
In and to the assets.
Yes, that is remember our debate before this?
I remember, but
I took it from the agreement.
Yes, but you omitted to read the first part.
Okay, no, it's fine.
Because if we go back to the first part, you would see what is it that NAMCOR was offering to buy.
Okay, but we don't need to debate it. It's written there. Okay?
No, no. I believe what is written there, it's what is in the commercial offer that was provided.
No, it's fine.
Yes, but you are in agreement. I don't, yes. With regard to the
what is
rights,
written.
title, and assets.
Yes, Your Worship.
Yes, so we can move on.
Yes. Now, then, I want you to then go to the. I'm starting now to show the distortion I spoke about that you caused public prosecutor to put to my client that Enercon would have walked away. And that is, I'll start doing that at page 55, Your Worship, and this is very important. Can you read the heading under clause 3?
Utilization of NAMCOR trading assets for storage of petroleum products.
Okay, that heading tells you NAMCOR assets, and those are the assets it will buy from Enercon, will be utilized, but it doesn't tell you for now in the heading who is to utilize it. You agree with me?
I agree.
The answer is coming in the next paragraph. Read paragraph 3.1.
Following the transfer of ownership of the assets to NAMCOR Trading pursuant to this agreement, NAMCOR Trading hereby authorizes Enercon to utilize and store only the petroleum products procured from NAMCOR Trading for the duration of the supply agreement between Enercon and the Ministry of Defense, subject to the terms of this agreement, unless this arrangement is terminated earlier by NAMCOR Trading for whatsoever reason.
Mr. Inambao, did you ever read this paragraph? When you
I
spoke
did.
to the, did you tell the prosecutor, alert the prosecutors of this paragraph?
Your Worship, actually what this paragraph,
No. Answer the, I'm not saying interpret the paragraph. I'm saying, did you alert them of the paragraph? Answer the question.
Your Worship, the evidence was gathered. The prerogative of the questions that the prosecution would ask when they are in the court, it is theirs.
Okay.
My duty as an investigator is to gather evidence and present it to the prosecution team.
Okay, good. Now, let me break it up a little bit. These paragraphs, and I'm not interpreting anything, it says, following, that it means after, the transfer of ownership of asset to NAMCOR Trading, pursuant to this agreement, in other words, the asset agreement, NAMCOR Trading hereby authorizes Enercon to utilize and store only petroleum products for the duration of supply agreement between Enercon and Ministry of Defense. Now, here comes the comment. It appears, as Mr. Mulunga confirmed in his evidence, Enercon was not going to walk away. It will continue supplying, but exclusively buying products from NAMCOR. Any comment? Only if you have a comment.
Your Worship, and I agree with you.
Oh,
But what this paragraph also says is the assets where the owners of the assets was NAMCOR Trading.
yes,
But
we are together. But they authorize us, my...
I think can the witness be allowed to finish?
Your Worship, and I'm answering this question based on the previous statement which I was made to read, Your Worship.
no.
Just answer the
Yes.
question.
Guys, just answer
we
the
are
question.
Yes,
correct.
where
I think I have to.
Yes, Mr. Namanja, please, can you let the witness? Yes.
I also have to bring to the attention of the court that the witness is not here to interpret the contracts, and we are not at trial now. And I think it's totally unfair to confine a witness to a certain paragraph, and if he wants to qualify a question, then he's precluded that you cannot answer that question. That's not what I'm asking you. Because if he's asking him to interpret, and that's what he's referring him to specific terms, that please confine yourself to this. And if a witness wants to refer to another paragraph, which actually wants to confirm or to comment what he's asking him, I think he should be allowed to make context to the question and not just to confine him. And that's why aspersions are being casted that the prosecutors didn't do this, because they want to corner the witness to a specific aspect, which is totally unfair.
Your Worship, may I just remind the court? You will remember, Your Worship, that I raised an objection about context. You will remember, Your Worship, that my learned friend took our affidavit, read only parts he wanted, confined the witness only to parts he wanted. When we raised this issue, we were told that is all I want. So, Your Worship, in the same manner, and of course this court ruled against us, surely this objection should be overruled, Your Worship, on that construction.
And Your Worship, I'm not asking. I said the function to interpret is with court. All I was saying to the witness, we are together that the asset became that of NAMCOR because of the asset agreement. All what I was saying, the agreement says then, after that, NAMCOR authorizes Enercon to utilize. That's all I was, and say, do you have any comment? Simple as that.
I am in agreement that you have put on record that you are not asking the witness to interpret the contract. Yeah. You are just asking him to comment.
Exactly.
Yes. So say...
Your Worship, can we get a ruling on the objection?
Yes, the objection, it's already been stated that the witness is simply being asked only to comment, not to interpret.
Exactly.
Yes.
Yes.
Then for that reason, the objection is overruled.
Thanks, Your Worship. We are indebted to court. I want to move fast, sir. Are you still at page 55?
I don't think I've provided you an answer.
Okay. Okay, Mr. Nyambali, do you want to finish?
Because before he responded or while he was busy, he rose for the objection.
Okay, can I just repeat it? Just
Sure.
leave other pages so that we move on. All I was trying to say, do you see that NAMCOR, according to the agreement, once the agreement is signed, was going to authorize Enercon to use the same assets?
That's right.
Okay, let's move on. Go to 3.3. Read it out.
Enercon undertakes to procure and ensure that only those oil/petroleum products as supplied by NAMCOR Trading are to be stored, handled, used, dealt, or distributed in, through, or from the assets. And the asset shall not be used used for any other purpose or in any other manner whatsoever.
Yes, this is exactly what Mr. Mulunga testified, that as Enercon get authorized to use those assets acquired or bought by NAMCOR, it must only use to store products acquired or bought from NAMCOR Trading. Any comment?
No. I'm happy, Mr. Namanje, because you are confirming that NAMCOR actually bought the assets,
yes,
and not the rights and titles.
It's the same.
We can move on.
Yes.
That issue we have already
exactly.
discussed. Yes.
So you are agreeing with this?
Yes, that NAMCOR was buying assets.
No, that's not what I'm talking about.
Yes.
I think you misunderstand. Are you listening to
You still want to go back to the question, or?
Because you don't understand.
No, Mr. Namanje, we can proceed.
Okay, but I want to confirm, because there is a secondary question, but you have no quarrel with this statement.
Yes.
Okay, very good. But this statement contradicts what was put to my clients by the public prosecutors. They were saying, you sold a dream, you continue, in fact, my clients were pressed, you continue supplying petroleum products, and NAMCOR did not take over the asset, did not get ownership of the asset. This statement you agree with, contradict what was put to my clients. Why do we have these contradictions?
I agree with the statement, Your Worship, 100%. And in order for me to qualify that statement, it begs a question as to why would NAMCOR, after already having entered in a fuel supply with Enercon on the 16th of March, buy assets and not use them at all? So why?
Are you asking me a question, sir?
Unfortunately, you cannot put a question to counsel. You can just answer the question.
It was not a question, Your Worship. I was just...
No.
Okay.
That's why I'm saying, do you trust NAMCOR, the complainant?
That question has already been asked.
Yes.
Can we move on? Yes.
Can you then go again to, I'm trying to expose the contradiction between your investigation and what was put to my client. 3.4, can you read 3.4 and 3.41? Start with 3.4, page 55.
3.41. Must I start there?
Yes. Start with 3.4.
Enercon shall not use or permit the use of the assets otherwise than in connection with oil, petroleum products supplied by NAMCOR Trading.
Okay, just hang on there. This is NAMCOR cementing or confirming exclusivity, that in those tanks, it must only be products bought by Enercon from NAMCOR. Do you agree with me?
That's what the term is saying.
And just for your information, this is exactly what Mr. Mulunga testified. Any comment? This is exactly what Mr. Mulunga testified in this court.
I was not there when Mr. Mulunga was testifying.
Okay.
He may have as well done that.
Okay, let's go to page 56. Can you read 3.5?
NAMCOR Trading shall be entitled from time to time to affix, paint, show, display, and exhibit advertising and other signs on or to the assets as it deems fit.
Yeah, just end there. Did you find any evidence of my clients prohibiting or impeding NAMCOR to put up adverts on those home-based stations?
No, Your Worship. We also must not lose sight that at the same time, when Enercon had entered into this agreement with NAMCOR, they had an agreement, an extending agreement with NDF.
No. All I'm trying to say, did you gather any evidence where my client impeded, prohibited NAMCOR, as entitled to put up advert or their name on those stations?
No.
Okay. Then, can you then read again 3.6 contradicts what was put to my clients by the Counsel for the State. Read it out.
NAMCOR Trading shall remain owner of the assets, notwithstanding the manner of installation, and Enercon shall not pledge, hypothecate, sell, or dispose of the asset, nor cede its rights thereto without the prior written consent of NAMCOR Trading.
Okay, remember you have read the paragraph that said NAMCOR bought asset but authorized Enercon to use them for product bought, and then this paragraph then protects NAMCOR's right so that the assets are not sold. Do you agree with me?
These assets are assets of NDF.
Oh, okay. I just want to park it there because I will be taking you to something that contradicts all that for you. But are you still talking about palms, canopies, and tanks?
Your Worship, the Annexure B that has been referred to lists all the
Yes.
items that are referred here to.
Okay, and those are movable assets.
The tanks,
Yes, tanks is a movable thing.
some of them are under the ground.
Even when they are under the ground, they can be removed. They are movable. If you do not know, I will take you to. They are movable. So they are immovable, you think?
Not to think, because Enercon at the same time had an agreement with the ministry.
Okay.
And that's where the problem, that is why we are here, is because Enercon had sold the assets that were already sold to the ministry.
Oh, where is the sale agreement of those assets with the ministry? Where is the sale where Enercon sold the asset to the Ministry of Defense? Where is that agreement?
Mr. Namanje, yesterday you confirmed your clients together with August 26 spent 58 million,
Yes.
of which this investment was going to be recouped in the period of 15 years until 2031.
Yes.
So at the end of that, those assets becomes the Ministry of Defenses.
Okay, I will come to that. But where is the sale agreement? You said those assets were already sold. Is there a written agreement to that effect?
The agreements between NDF and
Okay, I will take you there. But anyway, let's move to page 57. Okay, maybe just go back to page 56. Paragraph 3.4.2. I just want to read it out because you read it, Your Worship, you read it from 3.4. Enercon shall not, then 3.42, reposition, move, or remove the asset in a manner whatsoever without the written consent of NAMCOR Trading. Do you have any evidence of Enercon, after the agreement, removing or repositioning those tanks, pipes, and so forth?
No.
Just pick up.
No.
Okay. Then move to page 57. Paragraph 4.3 is, of course, Enercon indemnifying NAMCOR Trading. You see that?
57, which paragraph?
4.3.
4.3.
Yes, I want to move fast. That it's Enercon undertaking to indemnify NAMCOR Trading.
Yes, no, I'm there. I thought you were busy reading it.
Yes. You confirm. I just want you to confirm.
Yeah, yes.
Okay. Now, and then look at 5. It's then said, if you can just read it out, I will say stop.
NAMCOR Trading has the right at its discretion to terminate the agreement relating to Enercon utilizing NAMCOR Trading's assets by giving Enercon 1 month written notice.
Okay. So remember, what agreement is being, if you understand, I'm not asking you to interpret. If you cannot, please just say. What agreement is being spoken about in this paragraph?
It's the one we are busy reading, the asset purchase agreement.
No. But it's a sub-agreement of utilization of the asset. Am I not correct?
But it's contained in the same...
Exactly.
Yes.
That's why I say sub-agreement. I think that this is where, with respect, you misunderstood this case. Asset purchase agreement gives the right of ownership to NAMCOR Trading. That is the main agreement. Within that agreement, Enercon utilizes the assets.
The assets which are also at the same time intended to be properties of the NDA.
Nobody says that. We'll go that. So this utilization is about the asset acquired by NAMCOR. You agree with me?
Yes.
Okay, very good. Now, then, you have been in the charge sheet. Is it you that suggested to the state that the agreement relates to 9 service stations? Or it was not you? Who introduced the term service stations? Do you know where it originated? How did it find itself in the charge sheet? Who?
I don't know how it found itself on the charge sheet, but it's a term that an ordinary person uses when it comes to a filling station. So I could have as well used it in my statement. So.
But did you find the law applicable to service station? What law is that? Is it not the Petroleum Product and Energy Act,
Yes.
13 of 1990?
Yes.
Have you ever read that act?
I have, to some
You
extent.
read it?
Yes, I have, especially when it comes to the licensing,
Okay. Did you also read the regulations made by the minister in terms of section 23 of that act?
No, I haven't read the regulations.
Have you not read the regulation? I assumed you did.
No, I didn't.
How do you investigate this matter without reading?
It's an objection. What relevance is that to the regulations of this witness reading the regulations in the Petroleum Act? I do not think it's relevant, Your Worship, for the issues that we assist with. In fact, it has been said that time-consuming when I was going through the bank statements. So I believe it's also time-consuming to bother this witness with issues that are totally irrelevant.
Highly relevant because I will then be able to demonstrate these loose words being thrown that NDF, Ministry of Defense, owned assets, and that my client sold assets that do not belong to Enercon. So
You have asked the witness whether he read. He said he did not read
yes,
the document.
but I'm still entitled to go and inform him. The only reason why I asked whether he read is for me to assist him and take him to the regulation.
Yes.
Yes.
Yeah.
In fact, the record will reflect, Your Worship, that there were suggestions made by the state that this Enercon, Ecofuel, and so on, Your Worship, did not even have licenses to supply fuel. So it is highly relevant, Your Worship.
Highly relevant. I'm also demonstrating that this service station is an alien animal. We don't know such kind of things in Namibia. Can I proceed, Your Worship?
We can
May I-
proceed. However, as I've indicated, this is a bail application. We must confine ourselves to issues which are relevant for the bail application.
Your Worship, you would see that
Yes.
I will go to the end. I made a number of objections then. I was told, fine, it's a bail application, it's on record, I must let, or I will go to the most relevant thing. I will not.
That is what I'm saying. You
Okay.
remember we had your colleague there, just for the record,
Okay.
Mr. Bangamamwa. He went on when he was leading about the matter at the labor court,
Okay.
and you are the one who rose up. That issue has nothing to do with.
I-
so I'm just
Okay.
trying to remind you that can we focus on the issues before court?
No,
Yes.
it is definitely, in fact, it is at the center of the court,
Yes, so
what I'm going to deal with.
Yes, so can you confine yourself to those issues which
As the court,
will assist the court in
yes.
dealing with
Can you
this?
hand up the bundles, please? And give one to the witness. And Your Worship, I have given my colleagues copies, enough copies. Do you have the copy of the regulations, Mr. Inambao, in front of you?
Yes.
I have numbered them from page 1 to page 97. There is one judgment attached, but the regulation goes up to page 79, Your 80, Your Worship. Now, I will move fast. I want you to go directly to page 6. Definition section. And Mr. Inambao, remember I spoke about service stations, and there was assets spoken about, which I said they are movable. Okay, now let's just deal with certain definition, and I will ask you a few questions before we go to some section. Can you read the third definition?
Is it the licensed premises?
Yes.
Means the premises in respect of which a retail license is granted and which premises are described and specified in the retail license.
Okay. Now, physically, if you have tanks, some may be in the ground, some may be off the ground. A premises will always be there, land for it. Do you agree with me?
Yes.
Okay. It's not disputed that the tanks and pumps are at the premises or land owned by the Ministry of Defense. That is not disputed.
It's not disputed.
Okay. And it's also not disputed that what was sold to NAMCOR, it's not the Ministry of Defense land. Do you
No.
agree with me?
Yes, I agree with you.
Okay. But you are aware that land is transferred through the office of the Registrar of Deeds, and there must be a title, a document that is called a title deed.
That's correct.
Okay. Then we move down to an operator. Can you just read out? Mr. Mulunga testified about an operator. It's very important, Your Worship. Read the definition of an operator.
Means a person who is responsible for the day-to-day activities of a retail outlet or consumer installation where or not the person is located on the relevant premises during business hours, and whether or not the person is the owner of the retail outlet or consumer installation, and in the case of a retail outlet, if such activities are for on profit or loss.
Okay, in respect of those assets, the outlet that were there, the dispensing of petrol products to Ministry of Defense, Enercon was the operator. It had a retail license in respect of those home-based stations. Enercon was for its own profit.
Yes.
Okay, very good. Then, at page 7, Your Worship, page 7, Your Worship. The retail license that we spoke about, which obviously you can check at the ministry, which it's common cause, Enercon has, is then stated in the middle. You see the retail license definition there, which are granted under section Regulation 5. You see
Means a license issued in terms of Regulation 5.
Yes, yes. And now, can you, then this is the very important, the fourth line from the bottom. Can you just read it out?
Storage tank means a closed container that is used for the storing of petroleum products.
Okay. That is a movable. This something that is defined here is a movable asset, property.
Yes.
Do you agree with me?
I agree with you.
Okay. It does not get transferred through the Registrar of Deed at the Ministry of Land.
Of course, it doesn't.
Okay. So there is no title deed, like in respect of land.
There is no title deed, but your client signed a contract which is referring to a title as well.
Now, it referred to a title, not to a title deed. You must listen, sir. You must listen. Go to page 8. You see at the bottom section, this is very important. Number 3. Read number 3, Roman subsection 1 and A. Can you just read it? 3.1a.
3.1a.
Yes.
Operate a retail outlet or
No. Page 8, regulation 3.1a, starting with no person shall.
No person shall
Yes.
operate a retail outlet or conduct the business of a wholesaler unless authorized to do so under a retail license or a wholesale license,
Okay,
respectively.
let's just end there. You considered yesterday that the Ministry of Defense, according to that agreement between Enercon and Ministry of Defense, it is Enercon who must have all the required licenses to operate an outlet. It's not the Ministry of Defense.
I didn't concede. That's what was contained in the agreement.
Yes.
Yes,
You
so
are-
that was not me conceding. It
No,
was-
you agreed with me that
Yes,
the agreement
at
says
least
that.
that's the word that you are supposed to use, that I agree.
Oh, no, it's fine, the same thing. So all I'm trying to say, the party that have the statutory right, commercial right to operate an outlet in accordance with this regulation was not the Ministry of Defense, but Enercon.
You are right, and I don't know why we are going there because that has not been disputed.
No, lawyers, we know why I'm there, just answer questions.
It's already been answered. Can we move on?
Then, page 9. Page 9. Now, I want to skip that for a moment. Do you agree that in respect of an operator like Enercon, the obligation to have necessary permission for environmental protection purposes, it's again Enercon in this context?
That's right.
Okay, not the ministry.
Yes.
Okay. Then move to page 12 with speed, please. Those under section regulation 7, it provides for conditions of a retail license. You see that from 7.1a to H. You see that?
I'm there.
I'm saying, do you
I
see?
am there.
Okay. Then move to page 26. Yes. Can you read regulation 30, subsection 1b? Yes.
31B. Are you sure it's 31B or 2B?
2b, yes, 2b. Thanks, Mr. Inamba.
If any such change of information relates to
Then B.
B, in the case of a retail license, to a change in the name of the operator, the records required in terms of regulation 4.2 shall be supplied with regard to the proposed new operator, and the proposed new operator shall complete Form PP1 as set out in Annexure B, in as far as it is applicable, together with the application for the amendment.
Okay, why I'm asking this, Mr. Mulunga testified that, and he gave example at Husab Mine and other examples, that an operator, when you have installed and invested in assets such as an outlet, if there is another operator coming in, that operator will not have such right unless there is an agreement with the original operator. You acquire the asset, and obviously you have to get proper licenses to take over the asset. Do you have any comment?
No comment.
So in other words, what I'm trying to put it to you, this asset, this infrastructure, at all relevant time for the next 10 years, that the supply agreement was, the 10-year supply agreement was in force between NAMCOR and Enercon. They at all time owned by Enercon.
You mean NAMCOR?
Can you just repeat the question?
From the date of the sale of the agreement, sale of asset agreement, the asset that were owned by Enercon, in accordance with the asset agreement, will be owned by NAMCOR, according to the agreement.
According to the agreement,
Yes.
that was supposed to be the case.
Yes, it is the case. Let's then move to page 35. Speaking about storage tanks, you see that that is a section we debated about, where I made a comment to you that tanks are not immovable assets or properties. Remember?
Yeah.
Now, can you just read out the whole of those two paragraphs at section 46? And in this context, it's very important why I'm asking that question. Just read them out.
This regulation applies.
Applies.
Yeah, and that's what I said, applies.
Okay.
With an S.
Okay.
In the case of an above ground storage tank to a storage tank in a capacity of 2,200 liters or more, and in the case of I think it was supposed to be a below ground, but it's written a case of an below ground storage tank to a storage tank with a capacity of 4,500 liters or more. 2, every license holder or certificate holder shall, with regards to any replacement or installation of a storage tank or a remaining storage tank to which this regulation applies and which is in the possession of such license holder or certificate holder annually, not later than 28 February, duly complete Form PP10 as set out in Annexure B, and shall submit such together with information requested therein to the minister.
Yes. Now, in relation to this matter, did you investigate who have the required certification in relation to those tanks?
There was no need for us to go to investigate the tanks at the Ministry of Defense.
Yes.
As we went to the Ministry of Mines and Energy to try and find out as far as the registration and the licensing, and that we were given.
Okay.
Yes.
And
hence, during the investigations, it was established that yes, Enercon, Erongo, Ecofuel had the necessary registration and certificates.
And including certification for tanks.
That's right.
And those tanks are the subject of the sale between NAMCOR and Enercon.
Must I comment?
Yes.
The Ministry of Defense cancelled the contract of, the agreement between Enercon and the ministry last year in 2024.
Yeah. That is not what I'm asking.
Yes, and we are talking about the ownership. So, and I'm just trying to ascertain, or rather, I'm trying to provide information that
Okay.
when for example, the ministry cancelled this contract, the remainder, Enercon had claimed from the ministry that the remainder of the 10 years,
Yeah, exactly.
then that should,
It's entitled according to the agreement.
no. If the assets is for NAMCOR, then it's NAMCOR which is entitled to claim that money.
No. But didn't NAMCOR cancel the agreement? Mr. Ndeunyeme.
That was before. I cannot comment on the date, but
No, 2023.
we can leave it at that.
Why did you go there?
No,
If it is
because
difficult.
if NAMCOR was the owner of these assets from 2022 until 2023,
Yes.
they were entitled to a part of that.
Yeah, but are you their debt collector?
No.
Okay, so leave it. So now, at page 74, page 74, same document. Just keep it. Do you know that document in terms of Regulation 46? Just to be fair to you, Regulation 46 is the one that deals with the tanks.
I don't know the document, but this is a document that we have been referring to when we have been reading here from PPT 10.
Okay, yeah, exactly. And that is the annual document that you give to the Ministry of Mines if you are the owner of tanks. You give information. If you look at the bottom, A, can you just read out the information necessary annually from A to G? Just read it out, please.
The name and address of the owner of the storage tank, the type of the storage, the location of the storage tank, unless it is not intended to be in one place for more than 6 months, whereupon the storage tank must be indicated as having multiple temporary unspecified locations. The storage capacity of the storage tank, the type of materials used to manufacture the storage tank, the year manufacture of the storage tank, the year of the storage tank's installation, if available.
Very good. Now, let's then end with matters of your objection to bail. And let me just see with my colleague if I left something. Okay, now let's first start with the allegations of abuse of power in the process. Remember I said that it appears you come to court with dirty hands. Remember I said that.
You may have said it,
Okay.
but not to me.
Okay, are you aware that during the arrest, cell phone device was taken from Lydia Elindi by Inspector Anna?
That's correct.
Do you know why it was taken?
Your Worship, the cell phone devices were taken because when we arrested accused number 1, Mr. Willemse, we realized that
Number 1 is Mulunga.
accused number 2,
Yes.
we realized that he had made phone calls and it was possible, and therefore we believed that it's possible that information could have exchanged with other suspects. Because as we were there, he started receiving messages, he started receiving phone calls from various individuals who are part of the suspects that we were still looking at that point in time.
Okay, fine. When did you realize that? My client, Lydia Elindi, was arrested on the 8th of July. When did you realize that? 9, yes. Sorry, Your Worship.
Yes, Your Worship, that was on the 8th.
So that in relation to accused number 2.
Yes, that was in respect to accused number 2.
On the 8th.
Yes, on the 8th.
And that has nothing to do with Lydia Elindi.
Yes, Your Worship, we arrested Lydia on the 9th.
Okay, no. Whatever happened on the 8th in relation to the information you have has nothing to do with Lydia Elindi. Is that correct?
That's correct.
Okay. Then, so when did you decide as a group that Lydia Elindi's phone will be taken and that of the other clients of mine?
Your Worship, we were working through the night, looking for other suspects. In fact, Your Worship, by the time we finished that first day, I believe it was late in the night.
Yes. I'm asking, can you answer the question, when did you decide phones must be taken from my clients?
Your Worship, I suppose this was decided upon when we arrested the individuals.
You are saying supposed. You are the investigating officer. You must know, sir.
Your Worship, there was no time to go and look for the search warrant. As I'm saying, from the 8th when we arrested accused number 2, we worked through the night.
Yes.
Therefore, Your Worship, there was no time for us now to go and look for the search warrant to go and search.
Who spoke about the search warrant now?
I'm just trying to put the ground as to why there was no time for us to go and.
But you do not know when the decision was made to take the phones.
Your Worship, as I said, at the point we arrested accused number 2.
Okay. Was that the point? You took it instantly when you were arresting accused number 2, you say?
That's correct.
You took a general and indiscriminate decision that you will be taking everyone's cell phone.
Our plan, Your Worship, was to arrest everyone on that day if it was possible. But unfortunately, because of the time, we had to proceed through to the next day.
But the warrant of search against my clients, in particular Peter and Malakia, were obtained, signed by the magistrate already on the 3rd of July. Am I wrong? Your Worship, if you can look at the...
You mean the warrant of arrest?
Yes.
That's correct?
It's correct. So a period of 6 days passed after the issuance of the warrant without urgency and speed to arrest.
We did not obtain search warrants for the residents. Remember, we arrested you.
Yes?
We didn't obtain a search warrant for the residence of Mr.
Oh, I'm talking about warrant of arrest, if I refer
Yes.
to...
So initially,
Yes.
we were not going to take the cell phones.
Initially.
Yes, we were not going to seize anything because we were not having the search warrants.
Okay.
Eh? But upon apprehending accused number 2,
On the 8th.
on the 8th,
Yes.
we realized that there were messages because he had locked himself in the room before we arrested him.
Okay.
So at that point, a lot of information could have been.
Okay. What time did you arrest accused number 2 on the 8th? A day before my clients were arrested.
I believe that was around 11 or so.
Okay. And you were a group, a huge group, it appears.
Not a huge group.
Okay.
We were a group,
Yes,
but
yes.
not a huge group.
Did any one of you go and obtain, after you then decided on the 8th, you will have to take cell phone, did anyone go and attend to the application for a warrant of search and to seize my client's phones the next day?
No, Your Worship.
Okay. Then you just decided to go and take the phones without judicial authority.
Not without judicial authority. We believed the phones could have been used to exchange some vital, critical information.
Okay. What is the default position in Namibia in respect of seizing somebody's property? What is the default ordinary position, constitutional position? What is the default requirement?
You must believe the object was or is used in the commission or, to store evidence.
Yes, but in relation to authority, what is the default requirement?
Seized with or without a warrant.
No. Have you
Maybe
ever
you-
read Article 13(2) A and B of the Namibian Constitution?
You can just, try to explain what is it that you want me to get at.
It says that all searches must be through, on the basis of a judicial authority, unless then there are exceptions. So the default and primary requirement is the judicial authority. Do you know that?
Of course.
Okay. So it appeared to have been your deliberate decision not to obtain a judicial authority.
Your Worship,
You could if you wanted, because you were so many. On the 8th already you could have obtained a warrant of search.
we were time constrained, and we worked through that night, I believe, until late at night.
Okay. I want to put it to you, you deliberately approach the matter on the basis that you will not go and apply for the search warrant, you will just grab and take those phones. I put it to you, and that is what I am going to argue.
No comment.
Now, the password of Lydia Elindi was, by force, was taken, and also I think accused number 4. Why was it taken?
The rationalization for taking the phone was to use them as evidence, so that to have them forensically examined to see if there was an exchange of information between accused number 2 that was arrested with any of the accused.
Oh, so it was to intrude without a warrant in the data and content of the phone.
It was to get evidence from there.
What about her conversation with the husband? What would have happened to them?
What would have happened to them?
Yes.
Your Worship,
What protects them?
evidence, Your Worship, would have related to, if, for example, Your Worship, there was no communication between between her.
Look,
Mr. Ramanje, the court, before you proceed, the court will take a 15 minutes. Yeah. Before we proceed, as he communicated to councils that I have another bail continuation in Mungunda at 1400 hours, we are only proceeding up to 12:30. That will allow me time to arrange so that I can travel or drive during lunch hour, but also to attend to my matters I did in the morning in the regional court. Due to technical problems, I still have to deal with those matters on the system.
Mr. Court, please. Yes. May I proceed?
You can proceed.
Mr. Inambao, let me remind you, this matter I'm dealing with is not a small issue. It's not only an issue relating to lawfulness, but it's also a sensitive matter. I just want to let you know. Now, do you agree with me that taking someone's password to a phone to have access, uncontrolled and unrestricted access, is actually taking a key to a strong room where there may be sensitive documents, lawyers' documents, doctors' documents, anything, email correspondences and so forth, and trade secrets?
Your Worship, once a piece of evidence is seized, chain of custody must be maintained and kept in a safe and secure place where there is controlled access only until it is examined. Sometimes during the investigations, we do request for access so that when we forensically subject the devices to the forensic, we don't have to use brute force if the phone is unlocked.
No, look, you don't get it. You don't get it. The question is, when you take someone's password, you have unrestricted access to the content and data on the phone.
Yes.
Because there is no court order guiding you what you should not search for and what you should search for. Do you agree with me? If you take somebody's password to get access, there is nothing controlling you as to what you should have access to.
Your Worship, as I indicated, when we search phones, we don't manually search phones like you go on the device and search. You use a forensic toolkit to examine, to acquire the data upon which you will search for specific pieces of evidence in which you can actually even use, dates. For example, if you are looking for a specific date, you will go for that date. You go for the messages. You go for calls. You filter what you.
Yes, it doesn't matter. My client's instructions are that, and that is Lydia Elindi. On that phone, there are communications with her doctors, medical data on that phone.
It's possible.
There are communications of legal matter with attorney-client privilege information.
It's possible.
There are communications of very, very sensitive nature with her husband.
It's possible, Your Worship.
Sir, have you read the judgment of NAMCOR versus the Magistrate of Enana? I'm only asking if you have not read it.
No, I haven't.
Have you read the judgment of George Simata versus the Director of Anti-Corruption Commission on warrant of search?
I remember reading it, but it's been a time, some times ago.
Do you know that even when you have a warrant of search, it is only the officer specified in the warrant who can search, not every officer?
That's correct.
Now, the password that was given but to Inspector Anna, there is no court order, there is no guideline as to who will have access to the phone. Do you agree with
Your Worship, the phone was not given to Inspector Anna.
Okay. It was given to who?
One of our officers who was present.
Who is that?
Your Worship, I don't need to divulge the name because when we go out, for example, to a place, you have the person that is watching the person that is arrested, and then you had, to make sure they don't cause harm to themselves or cause harm to the other officers.
No. But the public prosecutor did not put contrary instructions to my client when she was cross-examined to say, no, it is not Inspector Anna.
The prosecutor was not present at the house of the Malakia and his wife when we arrested them.
Mr. Lamanje, just before
Ms. Elindi has
before
been
you
granted
proceed,
bail.
I just want to say, Mrs. Elindi is not an applicant for now in these proceedings.
Yes?
Yes.
It's
In the bail proceedings,
But-
where does that take the case for your other applicants in these
at
proceedings?
the beginning, Your Worship, we are entitled to do that. When you look at the case of S versus Likanye in the Supreme Court, Your Worship, the high treason conviction that was set aside, the state functionaries, in particular police officers, they are not permitted to unlawfully abuse powers they have, so that this court, were in consideration of bail, if the court were to find that there was
Mr. Lamanje, I understand, but in your line of questioning now,
yes.
Ms. Elindi is not here. She's not an applicant in this matter. I'm just asking, where does that line of questioning go
It's coming
in these
Okay,
proceedings?
is that what you are?
Yes,
It
yes.
is still relevant. It is still relevant because it's one and the same operations, and I'm going further to demonstrate that this is a pattern in this matter, abuse of power. It's the same thing, Your Worship. May I proceed to the next one?
I don't hear you. Yes, I'm not hearing.
It's a pattern, Your Worship, police officer. It doesn't matter, Ms. Elindi has since been granted bail. If in the same operation, the officers were using the power they have for legitimate purposes to abuse those powers, you are entitled to look at that in exercise of your discretion.
In a bail application, I'm saying.
Yes, in a bail application you can.
For now, because she is not here. Yes, so where does that line of questioning
Your
take,
Lordship, remember,
assist the court?
Malima.
Can we have only one speaker?
Yes.
Where does that line of questioning take the court in deciding the issue before it? That is my question.
Just the same way, we have had evidence about Austin Elindi, whose bail application is before another magistrate, Malima, who is, I do not know where he is. We have had evidence about corporate entities that are not part of this bail application. It's one and the same. We had a lot about many parties. In fact, and many other parties. It is relevant, Your
I hear we have a lot of other parties, but I'm just saying in a bail application now, does that assist the court to decide the
It does.
issue of bail
I
or
will,
not?
I will refer the court to case law that even when it is bail application, the fundamental rights to a fair trial includes a bail application. And officers of law enforcement, they are not entitled to abuse those powers.
I understand that aspect.
Yes.
I'm just trying to say, in the answering the question,
Yes.
whether to grant or refuse bail, that line of questioning.
Because
Yes.
if they were using power for an ulterior purposes, your Lordship, it also ties in with necessity of arrest and so forth. Your discretion, because Your Lordship, the principle is that you cannot assist state agents if they abuse power. The judgment of Mushimba and so forth tells you, Your Worship, that state officials can never use the power they have for good reason to break the law, even if it is in investigation of crimes. They cannot.
Yes, it appears you are not getting to my question. We can move on.
Oh, ask the court, please.
Yes.
the court said I must move on.
Your Worship, but I think contextually also, this court will appreciate that when the day comes when this matter comes to trial, the state would be entitled, Your Worship, to produce the bail record certified by the clerk as an exhibit in those proceedings, Your Worship. Now, if something is said about someone, whether he or she is no longer a participant in those proceedings, but who was a participant at the relevant time, Your Worship, and those issues are not placed in dispute, that is evidence that can be held against that person, Your Worship. So that is also the broader context that this honorable court should appreciate.
I know from the onset we had reached a point where the court even said, considering that bail proceedings, the record forms part of the entire proceedings.
Exactly.
So that is what.
I'm indebted to court. The court said I must proceed.
You can proceed.
Now, look, I asked you about I even lost where I was, just the last question.
Yes, you referred him to the issue of whether he knew or he read the case of Mr. George's matter,
Yes.
and he indicated some time ago.
Yes,
That was the last question.
Yes.
Yeah.
Remember, in that matter, for your information, the High Court of Namibia decided that your officers, only those who are specified in a warrant of search could conduct a search. If a warrant officer does not specify an officer, then that warrant will be unlawful. Do you agree with me?
And I know that.
Okay. Now, why did your team went for a password, assuming you are correct, you can take the phone, instead of applying for a warrant of search after the fact, after you have taken the phone?
Yeah.
Why did you commit two wrongs at the same time? One is taking the phone without a warrant. The second one is to proceed again and ask for the password and the PIN. Why?
In the course of investigations, in fact, if the court allows me just to step back a little bit earlier, you know, as the court and Mr. Namanje were busy discussing, you know, fresh memories are coming back. I remember in my examination in chief, I testified that we were looking for Mr. Malakia Elindi and his wife at a residence in Pioneers Park, if I'm not mistaken. So there was no way we would have gotten a search warrant for that house where we found them, because we were not aware of that house. And there was no way for us to have obtained a search warrant in that regard. And I just want to refer you even to, I think, one of the person that you were asking. We didn't have a known address. We had to get people from here and there. So we seized the phones, but as I was explaining earlier, that when we seize a phone, there are two options. You can seize a phone where a person, upon asking if they want to give the password, if they are willing to give, they will give you. If the person is unwilling, they won't.
So you are not answering the question. The point is, first of all, Mr. Malakia doesn't have residence in Pioneers Park.
I'm speaking under correction, but as
Why
far
are you
as
speaking under correction?
No, it's because I didn't go to that residence. In terms of the records that we had, it was a residence not in Windhoek. So when our officers went there, they went and found out that it's his property that he's renting. So, but by then we already had some intelligence that there's another house this side.
But you don't need an address to get a warrant of search.
No.
In relation to, can you just listen? In relation to a cell phone. A cell phone, you can get a search warrant to seize anything that you find anywhere, including on the person of a suspect.
We always try to put an address as part of the standing procedures.
Okay.
Put an address, In fact, even the magistrates, before they sign, in order to protect ourselves, if we want to go and search, we need to make sure that we put a physical address.
So in other words, you wanted to apply for a warrant, but the problem was that you didn't have an address.
No, no,
Is that what you are saying?
No, I'm saying from all the other activities that we had, there was no way we would have applied for a warrant when we found Miss Malakia on the other side.
But all I'm saying, but you are saying it as if it was the reason not for obtaining a warrant. You
No.
are contradicting yourself.
I'm
You
not co-
appear to suggest why you did not get it is because there was no address.
No, I'm saying despite there not being a warrant, there is no way we would have obtained the correct warrant, because even the address that we had, it's not the address where we found her.
Okay, this illegality is continuing. Up to today, you are in possession of my client's phone with access to that phone. This illegality is continuing at the time of this bail application.
Your Worship, at the time, investigations is still ongoing. We know that some of the suspects have even, run from one place to another. And, given what we had to work with on that day, we needed to make sure that we try to contain that. So it's not that maybe we are keeping and we are busy accessing your client's phone. The phone carries activity logs. Part of the requirements is that once you seize a phone, you isolate it from the network so that it doesn't anymore receive, messages or calls, because it would be tampering with evidence if we allow, if one of the investigators start fiddling with this phone, 2 days later after it was seized, it means we have tampered with that evidence.
Okay, but the point remains that phone is open. There's no restriction. Even if there are no calls coming in, the content and the data is open as this room.
It's only when it would be examined, forensically examined, and it's not going to be the phone that will be examined on itself. The data of the phone would be forensically examined through an examining machine.
Okay, when Mr. Mulunga was arrested, it's common cause, it's a notorious event. He was photographed when being picked up. Do you know about that?
I know about that.
How did it happen?
I believe if Mr. Mulunga was very honest, he would tell you how it happened. And I'm saying so because I was personally at that residence. When I came at Mr. Mulunga's residence, there was a vehicle of the media standing in front of his house. I requested for those people to move away from there. In fact, they refused. I had to tell them that, look, you are obstructing the course of justice. Mr. Mulunga all the time was watching from his CCTV footage. I'm sure I can confirm that. So I requested them to go away. Your Worship, we were so kind that I even asked the team to reverse the car in the garage or towards the garage of Mr. Mulunga.
Mr. Inambao, let me just, but did you tell the public prosecutors all this before Mr. Mulunga was cross-examined so that they pass that information to him to comment on?
No, they didn't. I'm not sure whether we spoke about it, but what happened is Mr. Mulunga is there. I was standing in his garage. I told the team, even one of the colleagues that was the driver of the van, I told him reverse.
Okay.
And I wish, at this point in time, I wish we had packed the van outside so they could have taken a proper photograph of him.
Just remain. This is.
No, but Your Worship, we cannot allow this. We have previously raised this
Court
issue.
is already questioning him that just answer the questions. Yes,
No, but it's
without-
not just about the questioning of answering the questions, Your Worship. It's the conduct, it's the demeanor that this court should admonish that witness on, Your Worship. That's the issue.
Yes, that's what they say. Just answer the questions and then we move on.
Thank you, Your Worship.
Yes.
This is a serious matter. Look, You knew that at the beginning of this bail application, State was given notice that one of our ground is that there was abuse of power and leakage of information to the media as part of the process of arrest and investigating. Does it mean that you did not advise the public prosecutors of what happened in relation to that leakage?
Your Worship,
What you are saying now, what happened?
if the prosecutors had asked me, I would have informed them.
Okay.
I would have informed them. In fact, as we were speaking with Mr. Mulunga, he did tell me that the media by then had already called him. So as to how they called him, I have no idea.
Let me just ask you, but do you agree with me that when you make allegations of what happened there, but they are not canvassed with Mr. Mulunga when he was in a witness dock, that is unfair? Because he has testified already.
This was not part of the evidence that we had collected. And I did not know that I would be asked questions as to whether we had leaked the media. I mean, Your Worship, I've said part of the reasons why we had seized the cell phones, it was to limit the knowledge that we have started arresting these people. We wanted to make sure that we have arrested people first, even before the media knows, because the moment we do that, suspects will start running away.
I want to put it to you. It is very clear. Did you dish out information that you are going to Mr. Mulunga's house? Did you tell all and sundry that you are going to that house as officers?
No.
I want to put it to you, sir. You invited the media. There is no way, if you did not dish out that information, the media would have been there. You are just hiding it.
Your Worship, I don't know whether I must answer this question.
You must.
Have any comment? Yes, you can comment.
No comment, Your Worship.
Yes.
No comment, because there has been no evidence that has been presented that ACC or ourselves as the investigating team has leaked this. And this would be unprofessional for an investigator to do that when you are still looking for. I mean, Mr. Mulunga was the second or the third person we arrested. I mean, we were still looking for more people.
Look, let me make it easy to you. But the courts in this country has already found against you in respect to Mr. Hairuru. It's something you do. It's a pattern of combat. I will, in my submission, show a judgment where Mr. Hairuru was arrested in front of media cameras. So it's something you officers do.
Object to that line of questioning. I think the witness has answered that he did not invite the media there. So how is it relevant if the witness has already said we did not invite, in fact we found them there? And even if that question was not put, it was irrelevant to us to put that to Mr. Mulunga. It was none of our concerns to ask how he was arrested.
I'm asking a different question, or what I want to...
The question has already been put and he has answered.
Exactly.
Yes, we can move on. Yes.
Why you do that is to do it so that the matter is massively published in the newspapers. You start working on your case to strengthen it before accused person appear in court, because you want a public narrative. That is your inappropriate, unlawful modus operandi.
That is a lie, Your Worship. Okay. Even if there was, at any point in time from the officers that we worked with, there was no point we wanted to discreetly do this so that we can arrest everybody that was involved and have them in the custody. Your Worship, we were looking for more than 10 people, and now we start to compromise the information with a second person. How would that assist us?
Another issue.
Your Worship.
Is Mr. Elindi facing charges in the amount of 480 million?
Your Worship, I have testified in this court. I have given the figures that are involved. If we add up those figures, they go to a little over 400,000. So I'm not sure where Mr. Namanje is getting 480 from.
Listen to the question. Is you caused my clients to be arrested, including Mr. Peter Elindi. Is that correct?
That's correct.
Is there any charge in which an amount of 480 million is involved?
I've just answered the question.
Which is? The answer is?
I've just answered the question a minute
I didn't
ago.
get it. Just repeat, sir.
I said, during the testimony that I've provided
Yes.
before the court,
Yes.
I've given the different amounts.
Yes.
I've given 35,747,615. I've given 73 million. I've given 238 million. So if you add those ones up, it will round up to about a little over 400
400 what?
million.
Okay,
So-
no, I will not leave you. But remember, I'm not talking about everybody. I'm asking Peter Elindi.
Mr. Namanje,
Yes.
you were here since I started testifying.
Yes.
Did you hear me testifying that Mr. Elindi is facing a charge of 400,000?
You see what is happening, Your Worship, now.
Sir, just answer. If you did not testify about 400, just say, I did not testify about 400.
I did not testify
Yes,
about
so
the
that
400
will move on.
million.
Exactly. But do you know,
480 million, I mean.
do you know that on the date of appearance, it was stated by the public prosecutor that all accused persons are facing charges of 480 million. That include the Elindis.
Your Worship, I was not in the court when the accused persons made the first appearance.
Was it you? I just want to know, because this is inappropriate and it's a wrong process in our court and it's manipulation. I want to ask you, does it mean that it was not you who passed that information to the public prosecutor who placed it on record?
Your Worship, we provided evidence to the court or to the prosecutors, following which the annexures were drafted and the accused persons appeared before the court.
Okay. Do you support such allegations against my two clients that they are facing charges of 480 million?
I've testified before this court and I've provided the values of what your clients are facing.
No, I know. But those values are not 480 million.
Yes,
Okay.
that's been ascertained.
I want to then put the following. It is in favor of my client that they cooperated at the time of the arrest. Both of them, they cooperated. They cooperated when you went to them. Nobody wanted to run away, Mr. Malakia Elindi. Peter brought himself to ACC office. They cooperated.
It's not like they had a choice.
That's not what I'm asking. They cooperated. I put it to you.
Yes, they were arrested.
That's not the question. They cooperated, sir.
Mr. Namanje, when a person visits my house with a warrant of arrest, I mean, they just have to execute the warrants of arrest whether I like it or not.
Yes, but did they cooperate or resist arrest?
They did not resist arrest.
Okay. They did not attempt to run away.
Yes.
It counts in their favor that they are Namibians.
They are Namibians.
It counts in their favor that they have substantial assets. Remember, in judgment, it says assets, it's a relevant consideration to bail. It counts in their favor that they have assets all over.
That's what you are telling me.
Yes? And you are not disputing.
I hear you.
Yes. It counts in their favor that they each one employ about 26 people.
I hear you.
It counts in their favor that, in fact, they were trying to conclude a mining deal that may result in employment to Namibians.
I hear you.
It counts in their favor that they did not interfere with investigation.
Investigations is still ongoing?
That's not what I'm asking.
Yes. Investigations is still ongoing?
That's not what I'm asking. I said it count in their favor that they did not in the past I'm talking about.
In the past?
Yes?
You are telling me so and I'm hearing you.
Yes? Now, do you know about the law, the principle that even if a court has some fear, it must still consider whether appropriate condition could be attached so that a person gets bail? Do you know about that principle?
That's correct.
Okay. It's not my client who will decide whether they will get bail. It's not your decision. It's not the decision of the prosecutor. It's a decision of the court.
Of course.
Do you know that the investigating officer's position is also, it is good for him to be heard, assuming there are conditions, the investigating officer, because you have no choice if the court grants bail.
Of course.
Now, assuming the court grants bail, do you rather let my clients be reporting each week or not report at all? Which one is better for you?
Your Worship.
Which one is better? No. The court is writing down. Which one is better?
I have no comment on that one.
Oh, okay. If my clients are granted bail, would they better pay 10,000 or 50,000? Which one is better?
That is to be determined by the prosecution. You know, I mean, I'm saying that is to be determined by the prosecution.
Oh, okay, that's fine.
I mean, yesterday you were telling me I'm the investigator, it's the state, so.
Okay, no. All I'm trying to say, you cannot choose whatever is
Yes,
better. Okay,
I'm
them.
not in control of that. In fact, it's up to the court.
Up to the court. Look, I will ask because given the poor and weak nature of the state case, in fact, I will ask that the accused person be released on warning. Any comment you have?
I will totally disagree with you. I've stood here 2 days almost testifying, demonstrating how much evidence we have gathered, and how advanced is the investigations. So I will totally disagree with you that how poor this case is.
Okay,
we have done quite significant work in this case.
Okay, fine. I will demonstrate in when I argue. But if they are reporting, do you prefer them reporting to Windhoek Police Station or ACC office, assuming they get bail?
ACC.
To whom should they report?
I think the investigating officer.
You
Then
yourself.
we will, of course, put some administrative measures in the office.
And they said they would also hand over their passport. Do you prefer that they remain with the public prosecutor or yourself? I see you are looking at my colleague. You will not assist him.
Well, I'm not sure the
Passports.
yes.
We maintain the decorum. The court
as-
is in session.
Yes,
Yeah.
I'm not sure the prosecution keeps
Okay.
exhibits.
Okay, fine,
So-
fine. So it's you, then the investigating officer.
Definitely.
Okay. Sometimes in some cases accused person get bail, but in addition the court attach another condition that they must not apply for traveling documents. Do you have a problem with such a condition?
No.
Obviously,
Just a
my
minute, just a minute. Yes, it's option time for the court to adjourn.
I only have 2 questions, Your
Yes,
Worship.
Mr.
I'm
Manager.
done.
Yes, we have been here since morning. It's fine, you can have your time. We just roll the matter to tomorrow,
Tomorrow.
if you are available.
I wanted to. Okay. Okay then. As the court please, to tomorrow then.
Available tomorrow. It's fine. It's
Yeah,
in
we roll the matter to tomorrow. So you are still under oath.
Thank you, Your Worship.
Yes, the court adjourns.